a little too often, but hey, you're going to have a much more. It's like, I know I'm entertaining, but you're going to have someone who's much more wise and responsive and more diplomatic with Mr. Saganash will be replacing. So I just wanted to thank you for the opportunity to be at this committee, and thank you for your excellent work, Chair. Thank you.
And Charlie, thank you for your great service and good company on the committee as well. You'll be missed. All right, with that, we'll come to order. This is the Indigenous and Northern Affairs Committee of Parliament, and we're meeting today on the hereditary land of the Algonquin people, for which we're very grateful. And today we're continuing our study of Bill S3, an act to amend the Indian Act, specifically eliminating sex-based inequities in registration. And we have three 10-minute panels in this first hour, so we're going to try to move along really quickly, and I'm going to be quite strict with time so that we can fit everybody in and get all the questions we need to. The first panel is the Assembly of First Nations with three people joining us there. Perry Bellegarde, National Chief of AFN, Denise Stonefish by video conference, Deputy Grand Chief, Association of Iroquois and Allied Indians, and also present in the room today is Stuart Woodkey, Legal Counsel. Welcome to you all, and without further ado, I'm happy to yield the floor for 10 minutes to you.
Chief Stonefish, speaks good. Go ahead.
Thank you for the opportunity to speak to you today about Canada's effort to eliminate sex-based discrimination through this latest amendment to Section 6 of the Indian Act. As indicated, I do represent 7 First Nations, mainly in Southern Ontario. I am also the chair of the Assembly of First Nations, their Council of Women, and this council is essential consultative body of the AFN under its charter, representing the interest and perspectives of First Nations women who are members of our 634 First Nations across Canada. As chair, I participate in meetings of the Executive Committee, our Chiefs in Assembly, and other meetings, including presentations to parliamentary committees on occasion. So as we are all aware, painfully, the Indian Act was founded on the goal of complete assimilation of First Nations as distinct nations. Since 1876, the Indian Act has undermined our kinship systems, our systems of governance, and many other aspects of our lives, including enabling the imposition of the residential school strategy. A primary tool to achieve those ends has been discrimination through targeting First Nations women. This is the third time Parliament has attempted to rectify the sex discrimination of the Act. In 1985, changes made under Bill C-31 left the task incomplete. In 2009, the British Columbia Court of Appeal found that the combination of the two-parent rule, the hierarchy of different types of status under Sections 6.1 and 6.2 of the Indian Act, and the second-generation cutoff perpetuated sex discrimination under the Act. And now the Desjardins case has forced Parliament to make a third attempt. We understand the compelling need for the government to respond to the discrimination identified in Desjardins. Unfortunately, Bill S3 will result in continued discrimination. In addition, the proposed amendments in S3 will compound the existing complexity of the Indian Act registration provisions by adding 3 additional subparagraphs to Section 6.1c. The basic approach of this bill is to continue arbitrary federal control over First Nation identity and simply push the residual gender-based discrimination down one generation. Our review of Bill S3 suggests other discrimination that will not be addressed. Number 1, under C3, which addressed the McIver decision, a woman who regains her status is deemed 6.1, and her children would also be eligible for 6.1 status, passing on through future generations. However, a woman who lost and regained status for any other reason other than that addressed under C3 was deemed 6-2, disadvantaging any future offspring. Number 2, C31 attempted to address the decision of the United Nations Human Rights Committee in the Sandra Lovelace case, as well as charter compliance issues. Now, under C31, a woman who regains status is deemed 6-1. A person, male or female, who lost and regained status under any other circumstances other than marriage under C31 is deemed 6-2, and any future offspring may be ineligible for status. In our view, Canada's continued imposition of a two-parent rule combined with the hierarchy of status transmission established by Bill C-31 under Section 6.1 and 6.2 lies at the heart of the ongoing sex-based discrimination. We note with considerable concern that there is apparently no remedy yet for the unfair and long-standing discrimination in the department's policies respecting so-called unstated paternity. I emphasize that these usually are not situations where paternity is unknown, but most often where a woman has other reasons for not identifying the father of her child. Thank you.
Thank you very much. Chief Bellegarde, are you going to use the rest of the time?
I
Very
will
good.
use
There's about 4.5 minutes left.
plus my 10.
I'm afraid not.
Oh boy.
Yeah.
Okay, I'm gonna have to go fast. Okay. Ninaskamon, kinanaskom tino kakia no timtek no akomaganak no tawinans manatua. I give thanks to the Creator for this day and acknowledge you all, my relatives and friends. Moving forward. The AFN recommends that Canada work with First Nations to undertake a joint review of federal law and policy and to work with us to ensure all of this work includes a gender and citizenship lens. Many aspects of the Indian Act constitute a violation of the treaties, the right to self-determination, as well as individual human rights. So much so, we must ask whether it is even possible to eliminate discrimination from an outdated piece of colonialist legislation intended to dismember our nations and citizens through gender-based discrimination and racialized concepts. We have an enormous challenge ahead of us to move past this terrible legacy. I'm sure you'll agree that simply making amendments to the Indian Act will not get us there. And whatever that path is, it must be driven by First Nations and guided by our inherent and treaty rights and the minimum standards set out in the United Nations Declaration on the Rights of Indigenous Peoples. I remind the committee that, under international human rights law, the enjoyment of the right to self-determination and individual human rights are interdependent and inextricably linked. We're encouraged by the Prime Minister's leadership on gender equality, his unqualified commitment to implement the UN Declaration on the Rights of Indigenous Peoples, and the enthusiasm of ministers, especially Minister Bennett and Minister Wilson-Raybould, to work with us to move beyond the Indian Act. And that important work has yet to begun. So when we're talking about status and citizenship, we've got to move beyond the Indian Act, because if we remain under the Indian Act, there's no more status Indians in 50 years. It's that simple. And so if we want to enjoy the right to self-determination, and we have that right, we have to exert that jurisdiction and occupy the field and determine who is not a citizen of our First Nations. That's up to us. Now, despite the Indian Act, we say that it's imperative that Parliament and the Crown work with First Nations to build a new relationship where First Nations law and jurisdiction over our citizens is recognized and respected. It's affirmed by the treaties, assertion of Indigenous sovereignty, and by the UN Declaration of the Rights of Indigenous Peoples. Now, the UN Declaration sets out minimum standards for respecting the collective and individual rights of Indigenous peoples, including gender equality. Gender discrimination and denial of the right to self-determination are violations of international human rights standards, including those expressed in and reaffirmed by the UN Declaration. The Act has been used as a piece of assimilation, forced assimilation, and as such it clearly violates individual human rights and undermines our collective rights to define and determine our identities as citizens of Indigenous nations. Now, I'm going to just cut through this because I only have how long? 2 minutes. I'm going to just, hey, it's better when I speak freely. So in here, we talk about programs and government is looking at, hey, we're going to make more status Indians here because of this legislation. And it's going to have a draw on two particular programs, the Post-Secondary Student Support Program 1, and as well the Non-Insured Health Benefits Program under Health and Welfare as the other one. So you're creating more status Indians. And they've identified some dollars and resources here to take care of those new Indians. But we point out here very clearly, where's the land? You're only making half a treaty Indian. You know, oh, okay, you got status now, you have access to these programs, post-secondary student support, non-insured health benefits. Under our treaty, we have 128 acres per individual, 625 per family of 5. You're creating other land obligations, and that has to be dealt with. That can't be put to the side. You can't just say, we're going to deal with female and male inequality. You've got to deal with it comprehensively and fully. That's what I want to say there. So now, under these Bill C-31 and C-3, what we're going to say, these amendments that give additional issues of treaty land entitlement, I said, have to be addressed. And there's got to be a meaningful dialogue beyond this committee. Not enough time. Not enough time. Take the time to do it right. Take the time to do it right. And so we're going to keep pushing for that. In Deschenaux, Justice Mass provided guidance to Canada stating, and this is my last 30 seconds, it does not, however, exempt Parliament from taking the appropriate measures to identify and settle all other discriminatory situations that may arise from the issue identified, whether they are based on sex or another prohibited ground, in accordance with its constitutional obligation to ensure that the laws respect the rights enshrined in the Canadian Charter. Parliament should not interpret this judgment as strictly as it did in the British Columbia Court of Appeals judgment McIver. If it wishes to fully play its role, instead of giving free rein to legal disputes, it must act differently this time, while also quickly making sufficiently significant corrections to remedy the discrimination identified in this case. One approach does not exclude the other. So the AFN is ready to work with Canada to advance rights recognition and reconciliation through jointly designed processes to ensure the full implementation of the Declaration on the Rights of Indigenous Peoples and to carry out a much-needed and fulsome joint law and policy review. That's it. We've got to work together on it.
Thank you very much, Chief Bellegarde and Ms. Stonefish. We're going to move right into 7-minute questions now, and then we'll, I beg your pardon, we're going to actually hear from the other two panels, and then we'll go into combined questions. So coming next is the Native Women's Association of Canada, and I'm very pleased to welcome Lynn Gruhl, Executive Director, Francine Joe, President, and Marilee Nojizik, Special Advisor and Liaison. Welcome to you all, and I'm happy to give you 10 minutes to share amongst yourselves as you would like to.
Thank you. I'm Francine Joe, President of the Native Women's Association of Canada, and I'm a proud member of the Shaken First Nation located in Merritt, British Columbia. While I worked for Canada Border Services for over 5 years, I'm also experienced in human resource management, economic development, entrepreneurship, and insurance, all in an effort to educate and encourage Aboriginal people to pursue their aspirations. I'm here today with Lynn Gruhl, NWAC Executive Director, and Marilee Nojizik, NWAC's Special Advisor and Liaison. First, I would like to acknowledge the Algonquin Nation of whose traditional territory we are meeting on today. I bring with me the voices of my ancestors, the concerns of Aboriginal women from across Canada, and the hopes of our future leaders, our youth. Since 1974, Native Women's Association of Canada has been the only national Aboriginal organization in Canada that represents the voice, the interests, and the many concerns of Aboriginal women. NWAC is made up of 12 provincial and territorial member associations from across the country. Our network of First Nations and Métis women spans the north, south, east, and west into urban, rural, on and off reserve. Our personal sense of identity, that we are part of nations, and NWAC needs to be part of any nation-to-nation discussion. It's crucial that our gender-specific perspectives are heard and acted upon. The Native Women's Association of Canada recognizes the Government of Canada's stated commitment to end all the known sex-based discrimination that is embedded in the Indian Act. This is a priority issue that has been long-standing and could result in missed opportunities to build our collaborative relationship and to ensure that we deal with the complex layers and multiple forms of sex discrimination in the Indian Act. There are 3 key messages I want to deliver today. First, the current backlog on registration and membership at INAC. Bill S3 leaves out Indigenous women and their basic rights are being denied. This is a fundamental breach of their rights to entitlements under the Indian Act, such as housing, education, health, and economic development. From a traditional understanding, Indigenous women cannot be separated from the impacts of colonization, systemic issues, and the policies and laws that have reduced the stability of our environment, the practice of our spirituality, and the expression of our inherent right to self-determination. We want to caution the government about the timeline. Indigenous women have multiple priorities at this time of the year. Children are in school with extracurricular activities. Women are preparing for harvest, hunting, trap lines. They're preparing for Christmas holiday celebrations with family and friends. The second key message I want to bring to you, engagement does not mean consultation, and a consultation does not mean consent. Indigenous women need to be the leader in these discussions. The two-part process, as described by the Government of Canada, is to be in reconciliation with Indigenous peoples through a renewed nation-to-nation relationship based on the recognition of rights, respect, cooperation, and partnership. At this point, we have had only one information session as of September 28th from department representatives. This does not constitute engagement, partnership, or respect. The government has already announced that they will have a two-staged approach in response to the Superior Court of Quebec's decision in the case of Deschanel, and this must be done by February 3rd, 2017. NWAC is particularly looking forward to addressing not only the systemic issues, but the impact those issues have had on Indigenous women, including, as I've said before, our personal sense of identity. We are also part of the nation. The lack of belonging and recognition by some communities when women want to return to their home community. The undermining of Indigenous women's governance roles and the ability to coordinate collections of issues. Also, the under-resourced of our organization financially. NWAC is the organization that has the expertise on Indigenous and gender-specific perspectives. The third key message I want to bring is that Indigenous women themselves have the right to determine their own identity. Article 33.1 and 33.2 of UNDRIP, with respect to Indigenous rights to determine their own identity and the structures in accordance with their own procedures. Of course, this is paraphrased. As a national Aboriginal women's organization that has spent over 10 years being undermined, ignored, and having our funding cut by 60% by the federal government, NWAC is in the process of actively rebuilding our capacity to substantively respond and coordinate a national response within a short timeline. Our current rebuilding status needs to be factored into the engagement processes at this time and should not be used as a way to undermine our participation in these key discussions and decisions. While we are currently working on addressing the procedures and processes that will drive the Missing and Murdered Indigenous Women and Girls Inquiry Commission, we are the lead organization for Indigenous women to bring their issues, their concerns, and sometimes their missing voices to effectively address these inequities. NWAC will work with all levels within the Government of Canada to end the inequities and discrimination that has been part of the Indian Act since 1876. Kukshem, Miigwech, thank you for your time.
Thank you, Ms. Joe. Is there anyone else that will speak on behalf of NWAC at this time? Okay, wonderful. Then we'll move right into the next panel and the final panel, which is the Quebec Native Women, Inc. We've got Vivienne Michel, President, and Cynthia Smith, Legal and Policy Analyst Coordinator. Welcome to you both, and thank you for being with us. And you've got 10 minutes to share between you as you would like. Thank you.
I will be reading this fairly quickly.
Bonjour tout le monde.
Good afternoon. I would like to thank the Creator for having brought us here today. And I also want to recognize that this is Algonquin territory, unceded Algonquin territory that we are on today. Ladies and gentlemen, parliamentarians, Femmes autochtones du Québec, or FAQ, recognizes that we are on unceded Anishinaabe land, and this has a particular meaning today given recent events in Quebec. It was on Anishinaabe territory that Aboriginal women courageously spoke out against the abuse and violence that they had endured at the hands of police officers from the Sûreté du Québec. Our organization believes these women and calls for an independent provincial inquiry in Quebec. FAQ is an organization of Aboriginal women which has been working since 1974 to end injustice so that our children can grow up with each other and so that they can know and be proud of their language, culture, and traditions. Since 1974, FAQ has been fighting against assimilation policies and sex-based discrimination in the Indian Act, which is the basis of this act. Still today, in 2016, our societies are suffering the negative consequences of this. According to Aboriginal oral tradition, in pre-colonial times, life between women and men was well defined. Men and women had different roles, but they were both considered equally valuable. There was mutual respect between genders and between generations. Aboriginal women enjoyed a high level of respect, equality, and political power that European women at the time could never have hoped for. Many Aboriginal societies were also matriarchal and matrilineal. As you know, this balance between the genders was violently destabilized by colonial policies which were knowingly implemented by the Government of Canada. Colonization had devastating effects on our people, notably through increasingly aggressive assimilation policies, which targeted women and children in particular. The Canadian government knew well how important women were to our societies, particularly when it came to transmitting knowledge. The government knew that if they wanted to reach its objectives and to settle the so-called Indian question, they would have to uproot our people, take away our lands and our traditions. It is written very clearly that this act was created to accelerate the dispossession of our land and to reduce the number of Aboriginal people in Canada. In its annual report of 1895, you can see that the Department of Indian Affairs had a clear position to attack our language and to assimilate us as a people. The means used to obtain this objective included attacking the pillars of our society, in other words, women, the people who transmitted knowledge, and also to attack children who were the future of our society. The Indian Act was a tool to reach this objective. It defined who was an Indian in Canada, and it did so in a patriarchal and paternalistic way. In the 1800s, Indian was defined as anyone whose father was an Indian, and any woman who married a non-Aboriginal would lose her status as an Aboriginal. This same act made the residential school system mandatory, and the goal of that, of course, was to kill the Indian within the child. This act was based on the objective of annihilating our societies and attacked our women and children and the transmission of our culture, language, and lifestyle. If Canada is sincere in its intention to reconcile with Aboriginal peoples, it needs to take responsibility for this by accepting this history and the impact that it has had on our society. FAQ believes that it is impossible to attain true reconciliation if our relationship is governed by an act that doesn't recognize our right to self-determination and which is based on racist and discriminatory policies. Since the 1970s, the Indian Act has been the subject of many court challenges. After the long and valiant combat of Mary Tuax, Jeannette Lavelle-Combière, and Sandra Lovelace, Canada, which had been refusing to recognize the sex-based discrimination in the Indian Act, was contradicted by the UN, which asked Canada to change its law. In 1985, Bill C-31 was adopted in the goal of mitigating some of this discrimination. However, it didn't end all discrimination. In fact, it even created some new forms of discrimination. It created two new categories of Indian status. So now Aboriginals were divided into their status depending on Articles 6.1 and 6.2, which is painfully close to eugenics. They created the concept of blood purity, which once again divided our people and imposed a foreign system on our Aboriginal peoples. In 2011, Sharon McIver continued the fight by fighting against gender-based discrimination in this act. The result was Bill C-3, which, again, was not able to fully end these years of discrimination. Here we are once again in 2016, dealing with the same issues. FAQ calls upon you, ladies and gentlemen, to recognize the absurdity of the current situation and the insidious nature of some of the discussions that we are having today. FAQ wants to recognize the courage of the men and women who led these legal battles. And we also recognize that any amendment is only a tiny drop in the bucket after the cultural genocide led by Canada against Aboriginal peoples. FAQ reminds Parliament of the existence of Article 33.1 of the UN Declaration on the Rights of Indigenous People, which says that Aboriginal peoples have the right to decide on their own identity and their own belonging to Aboriginal groups depending on their customs and traditions. Indian status is broken into categories and is granted according to criteria that are still very sexist. And even after proposed changes, it still represents a flagrant violation of our right to determine who we are, ourselves. In 2011, our association held a gathering of nations, and the theme was, one of the themes discussed was identity. We decided that it is language, culture, belonging to the land, values, and traditions that are the true foundations of our identity and our Aboriginal citizenship, rather than any measurement of blood or a government card that has a Government of Canada number inscribed on it. In the current context, our organization is calling on the Government of Canada to eliminate discrimination against women once and for all. Particularly women who, for various reasons, do not declare the paternity of their children. We also ask that women who have been suffering for discrimination since the period of prior to 1951 be able to recover their status before it's too late. Finally, we call upon the government to eliminate these status categories that distinguish status Indians from others and which create a contemptible discriminatory hierarchy that are based on criteria that are shameful and racist and based on blood purity. We also ask the Government of Canada to allow First Nations to decide for themselves who they are. We are aware of the government's intention to start a second phase in February 2017, and our organization would be happy to collaborate with you in this process. We have expertise on this file and have since 1974, and we believe that we can help make a good step toward reconciliation for the good of our people, our women, and our children and future generations.
Je tiens quand même à rajouter.
And I would also like to mention the very short consultation time in the 54 Aboriginal communities in Quebec. It was insufficient. We met Aboriginal women. I was invited to a consultation, but there were only 66 women present out of 54 communities. So the consultation has not been sufficient.
Well, thank you very much, AFN, NWAC, and FAQ for your testimony. We'll move swiftly into questions now so that we can make the most of our remaining half hour. And this is a 7-minute round of 7-minute questions, and I'll use the cards as well. When we get to 6 minutes, I'll hold a yellow and a red at number 7. And the first question is from Michael McLeod, please.
Thank you, Mr. Chair, and thank you to all of you for coming here to make the presentation. We've had a couple of presentations already, and this whole bill has been, the whole issue has been described as complicated and complex. And I don't think there's there's any Aboriginal person that's not affected by this bill. I'm from the Northwest Territories, and we have 5 tribal councils there and a large Métis population, and we all are impacted somehow with this issue. And as Perry has described it, it was a tool to create assimilation. And we've heard from Murray Sinclair, Justice Murray Sinclair, that residential school is doing the same thing. So this is an issue that's been around and has challenged us for years. It has impacted me and my family. I have cousins that have status, and I have cousins that don't have status, and who really can't explain why. You know, it's been very difficult to go up the ladder and say, well, brother and brother, but how come it fell into different parts? Now, we know that there was other influences. We know that the government played a role in it. We know the church played a role in it. A lot of times they were the ones kind of deciding who was going to fit into what category. And even people from the Hudson's Bay and those type of people had a role to play and decided where we're going to end up. But when I heard and seen that we were moving forward on this bill, I thought, I think the same way as most of you, that it doesn't go far enough. There's so many things we have to address. But having looked at it further and looking at there's a 2-stage approach, I think we need just to move forward with this. I think there is some merit to this bill. I'm very worried that if we are going to try to engage in a full-blown consultation process to discuss all the issues, we may be going for many, many years. I think this process to now, from the time it was initiated, took 6 years. And we may be in another government by then if we take the same amount of time. You know, we are part of the suicide study, and we know already that there's many components, many parts that needs to be addressed to start solving the despair in our communities. And if one piece was brought forward, I would probably welcome it. If housing was brought forward as part of the solution, I would welcome it. So I guess my question is along the lines what the Native Women have said, that this is only the beginning, and this is, you know, has to lead into something bigger. But I'll ask the question to all three, do you agree that this should be dealt with now? Or should we just completely hold off and try to do a comprehensive investigation of what needs to be done? Because we could go way back. We'll have to go, I think, and this, I think you can tell where I feel, how I'm positioning myself on this, that it may go back so far that it'll take years and years. So I think, you know, I'd like to hear what you think.
Ladies first.
We know how much the Indian Act has affected our families, our people. My biggest concern is our youth at this point. When we had the delegation come to the NWAC AGA in September, one of my own delegates from BC brought up the fact that her son had not received a status card. All of his cousins had. It took weeks after that. He finally got his status card. He finally got the benefits that he was entitled to. He got the benefits that his cousins had been receiving for the last 10 years. So for us to postpone this at this point, I think it would be unfair to our youth. Already, so many women have been working on this. Jeanette, Sharon, so many mothers have been trying to pursue this for their children. I don't think we can wait. Thank you.
Go ahead, Vivian.
Écoutez, j'entends qu'on veut.
Well, I can hear that people want to move things forward, I think it would be better to have better consultation. In Quebec, we have 54 communities. We have an urban Aboriginal population as well. So we want to know how we can perhaps hear other issues that you haven't heard about already. So better consultations. And also, I think you need to take the time to do it right. It seems like you show up unexpectedly, and we don't have the time to exchange or to consult properly. Our organization represents 10 Aboriginal communities in Quebec, including the urban population. And as the spokesperson for my organization, how can I talk about cases that I haven't even had time to learn about? Earlier, I talked about the recognition of paternity and the way that was imposed on us. That had a major impact on us, and it will on our future generations too. A Quebecer who doesn't have this recognition of paternity, well, will be recognized as a Quebecer and a Canadian. And then we also have the yellow card. Oh, what does that mean? Okay, yeah. So when an Aboriginal child doesn't have a declaration of paternity, then you have to go back to Article 6.1 and 6.2. So there's still a discrimination that endures there.
Just very quickly, I think on this, well, it's a decision by the Quebec Superior Court of Justice. So they said, hey, you've got till February 3rd to fix it, right? So you have that over your head. If you want to get an extension, then the Crown, Canada, must meet with Deschenaux and go jointly together. And I would encourage that. I would encourage the Crown and Canada and Deschenaux to ask. Now, just quickly, for that extension. So on this piece, and with all due respect, Chair, I want to you'll give me my minutes then. But just, so that's number one, because there's not an adequate consultation piece or process. So I'd encourage that to happen. The second point is that if you don't do this properly, and it's all about moving beyond this thing, the status card, you know, and you need a longer process to move beyond the Indian Act. I would encourage this honorable committee to encourage the federal Crown, this existing government that's there, to encourage a comprehensive federal law and policy review, and to put processes in place to move beyond the Indian Act. That's the bottom line.
Okay.
I'll leave it there.
Okay, thank you. Next question is Kathy McLeod, please.
Thank you, Chair. And, you know, certainly I remember way back in the 1980s as a nurse working in a community and going to visit one of the elders, and she told me, oh, you know, I'm not an Indian anymore. They took my card away because I married a white man who had died, and she was living in the community. And I can remember at the time thinking it didn't make any sense. In the community, clearly she was a member of that community. She was part of that community. And I don't know if she lived long enough to, because she was an elder at the time, and whether she ever lived long enough to be part of regaining her status. We had our first hearings on this issue on Monday, and to be frank, you know, the Liberal government has said very nice words in terms of, you know, the process that they're going to engage in as they bring forward legislation. And I was stunned to hear from Chief Obaswan and from Stefan that they weren't even consulted, and these were the litigants in this case. It was stunning in terms of the process and the failure to even reach out to the people that were the litigants and the chief that was a litigant in this case in any way to develop this legislation. So I think, you know, we can talk about process. I think that's an important conversation that we have about what's happened around this bill. I, like Michael McLeod at this point, you know, it's the legislation before us clearly responds to those specific circumstances. We understand that there is other, it sounds like limited circumstances that have not been addressed. I'd like to hear if it's a big issue to deal with those other little circumstances before we before the government heads into their phase 2? Should we be dealing with those ones that we're aware of that are in addition to what's here? Should we be moving forward with what's here? So I open that up both to the process and to next steps.
I go back, you need more time to get it done right. And even though there's that court order, like Bill S3 is there, you're making amendments now to the Indian Act. The issue is the Indian Act. That's the issue. You're tinkering with the Indian Act right now. That's what you're doing. And a court told you you have to tinker with it because there's unfairness, there's injustice there between male and female, and you're trying to correct that. I get that. That you're trying to fix it. You're putting a Band-Aid solution on you're putting a Band-Aid on a great big cut. You know, and it's not. It's just very, very temporary. You have to move beyond the Indian Act and start recognizing the right to self-determination and determining, you know, am I no longer a Cree Indigenous person if I lose the Indian Act's done away with tomorrow and I lose this status card? This status card we get? Our rights don't come from the Indian Act. We have inherent rights and we have a treaty relationship with the Crown. And we have to exert jurisdiction over our own citizenship. But that has to be also linked to a new fiscal agreement on total population on and off the reserve. There's issue of portability of rights and services and programs. You're not just a treaty Indian if you live on Little Black Bear. In the Corbière decision, chief and councils represent all their people on and off the reserve. Now there's going to be the issue and expectation of portability of services and programs and rights. So you can't just tinker with this. It's got to be more comprehensive, and it's going to take some time. 4 points. Longer consultation time to get it right. Support a law and policy review and all the outdated laws and policies that this government has, from comp claims to spec claims to additions to reserve to the inherent right. They're all based on termination of rights and title, not recognition. And we have to exert jurisdiction over our own citizenship. That's what we have to do. But that's got to be linked to a fiscal relationship with the Crown, which we're working on. And then don't forget the land issue. Because I remember in 1985 when Bill C-31 came in, all of our chiefs said, the Crown's just making half a treaty Indian. You know, you get this status card, you have access to post-secondary funding program, then you go to national non-insured health benefits through health. Land. Where's the access to land? So you can't, if you're going to do this, do it properly and comprehensively. That's my advice. 4 points.
Anyone else? Yeah, please.
In regards to some of the time constraints, I mean, it's not really our business to tell you how to do your business. But what we have heard in just the one session that we were fortunate enough to have on the 28th of September of this year, with members from the women of the communities from across this country, a card will not expire me. You cannot tell me who will be and who will not be an Indian. But what do you want us to start doing? Inbreeding on community so we can retain membership? What do you want us to start doing? We've already given up enough. I'm trying to think of the frustration that they had. Do you realize that they were given only a half a day to talk about this very important issue without even having had prior time to study the document, to review it, to have some input with their communities or with the women in their communities whom are facing some of the issues regarding membership, citizenship, equality, and the rights that are inherent to them? Do you realize the frustration that the registrar of the department felt when she got in that room and was totally overwhelmed by the number of cases that have been going on for 7 or 8 years, and then this comes about? How much are we going to prolong the backlog? Our solution, hiring some more people who know how to deal with these issues, who know how to look at genealogy and research and getting it done for you. Thank you.
There are 30 seconds. Okay, all right. There's just half a minute if you'd like to go ahead, Chief Stonefish.
Yes, I'll be quick. I won't do any repetition of what has been said previously because I agree with a lot of the things that had been said. And I think that one of the other things that we need to consider too, I mean, this has caused different classes even within our own nations. And so I think that we do really need to have meaningful dialogue. And I do believe that from what has been said today, that NWAC and other women's groups are ready and willing for dialogue. And so even the First Nations across the country are ready for this nation-to-nation dialogue on this, and we need to do something.
Okay, thank you for that. We'll move to the next question now, which is coming from Romeo Saganash, please.
Thank you, Mr. Chair. And I've been in this business for more than 40 years now. And to wrap my head around this one is perhaps the most difficult task I've had in those 40 years. Really. Because how do you, quote unquote, improve? How do you improve a racist, colonial, paternalistic, archaic legislation? No. Can't do that, right? And I think a lot of people in this room understand that. So, are we to continue on that path, Mr. National Chief? Or do you view this as an opportunity to change for something really nation-to-nation like? You mentioned we need to take the time. I noted those words. So the National Chief misunderstood. He thought he had 10 minutes. He took 4. I'll give him the next 5.
Merci beaucoup, mon ami.
Thank you very much, my friend.
Romeo, and good question. And the question about continuing down this path, it really is, and I stressed it earlier on to all the honorable committee members, the process to move beyond the Indian. It's been here since 1876. And that's not where our rights flow from. We have inherent rights. And this particular issue about citizenship is really fundamental to who we are as nations. And so moving beyond the Indian Act, I'm going to encourage, the members of Parliament here to encourage the Prime Minister and Cabinet to make sure that those processes to move beyond the Indian Act are in place. And whether you do it band by band or treaty area by treaty area or nation by nation, to work towards another jurisdiction and work towards another recognition. Our ultimate dream as Indigenous peoples, and you go back to the RCAP report, which speaks about another jurisdiction and another law recognized in Canada, in addition to common law and civil law, and that's First Nations law, and recognition of First Nations governments. That's the ultimate goal where we're going to have to work, and that means moving beyond the Indian Act, but it means recognition of our rights and title. And the most fundamental right we have is the inherent right to self-determination, to determine our own citizens, determine our own forms of government. And that's what we have to do. And we have to make space in this beautiful country called Canada for our laws to be recognized. Because you only go common law, civil law. Well, there's First Nations law, there's Creators law. Where is the space for that? That's what reconciliation will mean, once that's recognized. And then we move beyond the Indian Act. Because if we stay under this Indian Act, within 50 years, there will be no more status Indians in this country called Canada. No more if we remain under this. And we don't want that. Our children and grandchildren don't want that. Respect for rights and title and jurisdiction, but then it's comprehensive. It's got to be linked as well to fiscal. It all has to be linked. To me, that's the process we have to embark on. And it can't be done right away. And there's fear, even amongst our chiefs. Oh, if you do it the Indian Act, what will replace it? And I've always said it this way. If you do not want a federal law or provincial law to apply, create your own laws and occupy the field and exert that jurisdiction. That's what we need to have in place. I'm going to leave it there. 3
minutes.
Oh, okay.
Right on. Je pense que vous avez entendu, Madame Michel.
I think, Ms. Michel, I think you heard the question that I asked to the National Chief. Would you like to use the rest of my time to answer that as well? Yes. So, I'm hearing myself in my earpiece here. The Indian Act is obviously obsolete. I think we can all agree on that. And it's still promoting assimilation. In terms of what we would replace it with, I do have some concerns because it's perhaps the only document that recognizes that we exist in some sense. As long as we don't have our own law, our own way of operating, then we have to rely on this, but only in the short term. We can't rely on it in the long term. So this is just sort of a safety net, a protective mechanism. Canada did adopt the UN Declaration. It's a beautiful declaration that was written in collaboration with Indigenous peoples. It has to do with human rights. It has to do with universal rights. And it was very well written. It really does define our aspirations. So I think we need to sit down with the declaration and to work on it even further so that we can put forward even better proposals, because it still isn't being applied by Canada, really. So I think that we already have something to work with. Well, we have the Indian Act, where you say how we have to work in our communities, where you recognize who is Indian and who is not. And officials in the Department of Indian Affairs receive a request and say yes or no. Well, why don't we have that right? Why don't we have the right to choose who is Aboriginal ourselves? We know ourselves and you don't know us. That's all I wanted to add. Thank you.
Thank you. I guess we'll leave it there. There's a few seconds remaining. Next question from Gary and Anna Sangre, please.
Thank you to the panel for your candidness this afternoon. And before that, I want to welcome my friend to the committee and thank Mr. Angus for his great advocacy. I'm a little confounded this afternoon because I think there's a strong realization. I know when we embarked on this of the serious failures of the Indian Act, and I think Romeo's sentiments I fully share in terms of its premises. The challenge that we have is that we have a deadline that's set. So the issue is, how do we balance that, if we balance it? So I'm going to ask you some very pointed questions, and I really like all three organizations to give a very direct answer. So with respect to the current S3 legislation that's before us, do we move forward with it along with the consultation process for the phase 2 of it, or do we not move forward? And the third question is, do we go to court and get the extension? Because it seems like I'm hearing all three of this. So I'd like to get a direct answer from all of you. And then if we are going to court, what is the timeline that would be appropriate? Because you've all raised very complex issues. And in fact, issues of national self-determination can happen in 3 months. So how do we balance that? So I'd really like to get a sense from all three.
Oh, we're all up. Yeah. Okay. You're right about the timeline. I'm not sure who creates these timelines. It always puts us under pressure. It's putting Native Women's Association under pressure because we haven't had time to speak with each provincial and territorial member. We haven't been able to go out to the communities ourselves and ask the women who are directly affected. But again, the issues that are affecting the youth that don't have this status card to get the benefits that are their human rights, I can't not say we should not move ahead. It's affecting our youth at this time, and every day we're losing our elders who are also affected. At this point, I mean, I lost my own advisor in the late Senator Len Marchand. I know he would have had a lot of advice to provide at this point. So I would like to see us move forward.
Thank you.
Did I not?
Oh, I would say, on this one, to do it right, I would encourage you to go to get an extension. And because you're still going to leave some young people out. Some are going to be covered, but others won't be. So I'm going to say, go with the Crown, go with additional people, and ask for an extension. Ask for an extension and get it done right, get it done properly. That way, it's going to take the time, because I know you got push factors, right? You got a push factor. You've got a legal. So the judicial branch is telling you very clearly, as an executive branch and legislative branch of government, fix it. We're saying it's really rushed. So I would encourage to get together, the Crown together with Deschanel, and make a court application for an extension, and put the proper resources, both human, financial, that you get out to the First Nations women's groups across Canada, work with their AFN chief of our Women's Council, work with NWAC and all the women's organizations across here to get input and get it done properly. And then that way it's more comprehensive and more complete that way. That's what I'd encourage. And then that's immediate and long term. Go beyond the Indian Act.
So Grand Chief, on that, I want to just pressure you a little bit on the timeline, right? What would be realistic, given the scope for an intermediate solution? Because we also want to make sure that we don't continue to disenfranchise young people, as your colleagues have said.
There's some wrongs you want
to
to
how do we
correct.
find that balance, and what's the realistic timeline that's required for something like this to take place?
I don't know. I don't have a right to say, oh, it's 3 months, 6 months, 9 months. Like, all I'm saying is you need more time. And bearing in mind that there are some young people that might still feel left out, but you're still going to leave some out. Just take the time. I don't know. I don't even want to say, is it another year? But soon. Like, just 3 months. It's just total. It doesn't make sense. It's too rushed. And I think you got to take the time, whether it's a year or two, like, not too long. What's the balance? I don't have the answer here, but all I know is February 3rd is not the right time.
And in 30 seconds.
If I may, as the chair of the Women's Council for AFN, I agree that you should go to court and for the extension, because you do need to take the time. I mean, this has been an issue that's been on the table for a number of years, but I don't think you covered it in a sufficient way that you provided the opportunity for the First Nations and their women to have input and feedback. Thank you.
Yeah, I'll just yield it to Ms. Michelle to respond, please.
Well, during my speech, I mentioned the lack of consultation time. That's a reality. So we need more time to have better consultations. And consultations shouldn't just last just one day. This is a question of identity, and that involves language, culture, and all of the issues related to identity. That might be exhausting and exasperating to go through all these details, but it's very important. When we talk about identity, we're talking about the whole territory, the language, and the culture. It's a very vast subject. And if we're talking about my identity, you're talking about me as an individual, and I think it should be up to us to say what we want. So if you really want to make changes, then we need to take the time, and we can make suggestions to you. So we need more consultation time, and then we also need the funding to be there so that we can have appropriate and sufficient consultations.
This is the final question, so please, sure, just a few seconds if you would.
Thank you. I think what's very important also to keep in mind is when you look at the Deschanel case, they request that all gender-based discrimination is tackled. The thing, though, is what you're bringing up to the table with S3, you only go as far as 1951. But the gender-based discrimination started way before that. So I think this is something that is very, very important to also keep in mind.
Thanks for that. And those will be, unfortunately, our last words from this joint panel. We've got to move on to, we've got another panel coming up right behind you in the next hour. So I want to say sincere thanks to each of you for sharing your wisdom and well-considered testimony today. Thank you. We'll have a brief suspend while we switch, but let's please switch to the next panel very quickly. Okay, we're coming back to session now, and I'm very happy to welcome two groups to the panel in the second hour. The first is the Congress of Aboriginal Peoples, and welcome to Robert Bertrand, National Chief, and Frankie Cote, Senior Manager, Engagement. Welcome, and thank you for giving your time to us today. I'm happy to turn the floor over to you for 10 minutes to share between the two of you as you would like. And then I will show you a yellow card when there's 1 minute remaining and a red card when we're out of time. Thank you very much, and we'll get right underway.
For opening statements, Mr. Chairman, I'll be using the 10 minutes. Dear Chairman, Vice Chairs, committee members, representatives, and guests, my name is Robert Bertrand, and I am the National Chief of the Congress of Aboriginal Peoples. J'aimerais reconnaître le territoire.
I would like to recognize that we are on traditional Algonquin territory, and we are privileged to be meeting on that land today.
The Congress to address this important and necessary discussion on Bill S3. I would like to commend Prime Minister Justin Trudeau and the federal government for withdrawing its appeal concerning the August 3rd, 2015 Superior Court of Quebec decision on the Deschêneaux case to the Supreme Court of Canada. The decision to address the Deschêneaux case in a two-staged approach to eliminate known sex-based inequities, in Indian registration and not to be limited to the specific facts of the Deschêneaux case is promising to hear. Since 1971, CAP, formerly known as the Native Council of Canada, has committed itself to advocate for the needs of off-reserve status and non-status Indians, Métis, and Southern Inuit peoples. We also serve as the national voice for its provincial and territorial affiliate organization, or PTOs. Our PTOs are located across the country, from the western coast of BC to the eastern reaches of the southern Labrador. CAP also has a National Youth Council. Le Congrès représente un nombre très
We represent a significant number of Aboriginals in Canada. In fact, we currently represent more than 70% of Aboriginals living off reserve.
45 years, CAP has committed itself to address issues affecting our constituency and has been actively involved in cases which concerned sex-based inequities in registration, which led to the passage of Bill C-31 and Bill C-3, known as the MacGyver case. In working together towards reviewing Bill S3, there are two current instances which CAP feels are models for effective change for reconciliation with off-reserve Indigenous peoples. Number one, the United Nations Declaration on the Rights of Indigenous Peoples, UNDRIP, and secondly, the Supreme Court of Canada's historic decision on Daniels versus Canada. 17 years ago, our former national leader, the late Harry Daniels, along with CAP, went to the court to force the Canadian federal government to acknowledge that Métis and non-status Indians are Indians under 9124 of the Constitution Act, and that the federal government has a fiduciary responsibility to them. Le Congrès a intenté cette poursuite.
CAP launched the lawsuit, funded it at every step, and supported it at every step of the legal process. And I am very proud to have been able to announce on April 14th, 2016, that we finally won.
Took the Daniels decision accorded by the Supreme Court of Canada to end the judicial limbo of Métis and non-status Indian, stuck in the passing of the buck between the provinces and the federal government as to who should we deal with and who as fiduciary responsibility. The road to reconciliation with Indigenous peoples whom CAP advocates on behalf of could not have happened until the Daniels case was addressed. Regarding Daniels, Supreme Court of Canada Justice Rosalie Abella stated, "As the curtain opens wider and wider on the history of Canada's relationship with its Indigenous peoples, inequities are increasingly revealed and remedies are urgently sought. An opportunity for such remedies lies in the distinct possibilities for the federal government and the Congress to come together under progressive reconciliation in the form of engagement and consultation on all issues affecting our people. This most certainly includes Stage 1 action on the Duchesneau versus Canada. As part of the proposed legislative amendments to address residual sex-based inequities in Indian registration, some individuals that identify as Métis and non-status will become eligible for Indian status. I would like to clearly state that the Métis Nation, as expressed by the Métis National Council, does not speak for all Métis. However, the Congress respects the fact that they are a Métis Nation as defined by themselves. I respectfully submit that we, as an Indigenous people who are part of the Congress of Aboriginal Peoples, have, for 45 years, embraced the rights articulated in Article 33 of the United Nations Declaration on the Rights of Indigenous Peoples, or UNDRIP, which states that Indigenous peoples have the right to determine their own identity or membership in accordance with customs and traditions. Indigenous people have the right to determine the structure and to select the membership of their institution in accordance with their own procedures. Under Article 4 of UNDRIP, Indigenous people, in exercising their rights to self-determination, have the right to autonomy or self-government in matters relating to their internal and local affairs. Under Article 18 of UNDRIP, Indigenous peoples have the right to participate in decision-making in matters which would affect their rights through representatives chosen by themselves in accordance with their own procedures, as well as to maintain and develop their own Indigenous decision-making institutions. I quote these articles because they carry a direct impact on CAP's constituency. We have a multitude of different Indigenous peoples from different nations who live off-reserve in communities. In terms of Bill S3, as I previously started, I am pleased that the government decided to withdraw its appeal in the Duchesneau case and has undertaken this process to address the gender inequalities that continue to exist in the Indian Act even after the enactment of Bill C-31 and Bill C-3. Bill S-3 will give Indian status to those that should have had status all along and will see those born after 1951 become status Indians. However, the Supreme Court of Quebec was clear that amendments should not be solely focused on the facts in Duchesneau. With that said, I do not see why the government stopped at 1951 and did not go back further. For example, Bill C-31 went all the way back to the 1860s. Why is Bill S-3 different? There could and almost likely will be individuals falling through a crack due to the gap between the 1860s and 1951 not being addressed. I acknowledge that these issues may be addressed in Stage 2, but that does not immediately help the person who may be entitled to Indian status and the benefits that come with being a status Indian, such as the non-insured health benefits, NIHB, and post-secondary education. Ce sont des questions, Monsieur le Président.
Mr. Chair, these are questions that remain very important for CAP. As the spokesperson for status Indians and non-status Indians off reserve, as well as Métis and Inuits of the South.
Chance to speak with you today. Miigwech, merci, thank you.
Thank you very much, Monsieur Bertrand. We'll move next to the Union of Ontario Indians, and with us we have Jeanette Corbière-Laval, Citizenship Commissioner with the Anishinaabe Nation. Welcome, and I give you the floor for 10 minutes.
Okay. Miigwech. Gitchinen Giwik make Wibajana Gomampi. Giwedden and Dijanakas, Wikwam Kong Don Jabath. I'm giving you greetings from my people, the Anishinaabe Nation in Ontario, and I'm a member of the Wikwemikong unceded territory based on Manitoulin. And I also shared my Anishinaabe name, which is Giwetnanang, which is North Star. And just listening to the previous presentations, I am here to share with you the work that we have been doing within the Anishinaabe Nation. And it is what we are all talking about, and it's called the Anishinaabe Nation Citizenship Law, or Edbendagsajik, those who belong. This is the appointment that I was given by the Grand Chief of the Anishinaabe Nation many years ago. Well, not that long ago, 2007 actually. But just listening to everyone, and I think looking around the table, I was thinking it might be good to just take a few steps back and take some of the time to share with you my own personal experience with the Indian Act. And it might have some relevance and bearing on what we're going through right now. This is my status card. It says Jeanette Corbier Laval. And for 15 years, I didn't have it. Simply, and by the way, this one expired too. And the irony is, you know, how can a citizen or a status member expire, you know, but that's what happens. But in 1970, I married David Laval, who was non-Indian, and as I pointed out, I was a member of the Wikwemikong unceded reserve. And then my rights as a member of my community was automatically taken away, and I received a check in the mail for $35, which said, that was it, you're no longer a member. And it was really hard-hitting for me because I grew up there, my family's there, and that was my whole life, even though I did travel to Toronto where I met my husband, but that was for work. But I guess what I want to share with you is that changes and the revision of the Indian Act has been ongoing. Prior to that, it was revived, so our people could imbibe in liquor. And now, in 1970, when I looked at the Indian Act and the impact it was having on me, and no choice in the decision, it gave me that challenge, and I took it all the way through to the Supreme Court of Canada. So that's the Laval case, of which Bill C-31 was the result many years later. But in 1970, we approached the chiefs, you know, at the time it was National Indian Brotherhood and the now the Assembly of First Nations. But no one really wanted to tackle this sex discrimination within the Indian Act because, of course, it only affected Indigenous women or Indian women with status. And we're still dealing with that now. Here we are, 46 years later, same problem. So it's been ongoing, but nonetheless, this is the task you have been given as members of this committee, and I do understand the timeline. However, just realizing the hardships that have taken place to many of our people in our communities, decisions have to be made, and change must be made. It is not relevant in this day and age to continue to have this kind of discrimination, especially against our women, within the laws of Canada. So it must be changed. And I would like to see whatever we can do as members within our Anishinaabe Nation to assist in bringing about this change. Just to, I guess, relate also, so in 1973, we lost by one vote. So there wasn't any change for me. And as I said, I didn't have my Indian status for 15 years. However, I guess the biggest impact was that legally I would not have been able to even visit my family or go and reside with my parents and my aunts and my community. And this is also who I am. I have my language. I grew up there. And, we have our own spirituality. When we say that Indian status is only getting access to health benefits, that's not true. To us, this is who we are as a people. That recognition, no matter where you go, you can say, I am a member of my community, I am Anishinaabe. For me, I'm an Anishinaabe Kwe, which is an Indian woman. And when we dealt with it in 1972, 73, we didn't have any Aboriginal women's organizations. But because of the determination of our women and the fact that no one was listening to us, we had to get that word out. And so we formed our own provincial Aboriginal women's organizations in 1973. And here they are. They just left. And I am a member of the Native Women's Association of Canada as well through our provincial group. I guess what I'm really trying to say is there have been changes and they have been good. They haven't been perfect. And here we are. Then Sharon MacIver had to work on behalf of her grandchildren. So that went to the BC Supreme Court, and as you well know, then we had Bill C-3. So we got Bill C-31, C-3, and now we have the next step. So it's ongoing, and it won't be resolved because there'll be other aspects coming out. And I hear what you're saying is that the Indian Act is not the best. However, it is the only protection that many of our people recognize, the only protection that we have. And unless we can be assured that we will have something that is strong, that we will be a part of, that we will have a say in that development of a governance structure or our own constitutions, our own Citizenship Act, it just can't be done away with. So it may take a little while longer, but as members of the Anishinaabe Nation in Ontario, there's 40 First Nations who are members. We have started on that process. So I don't know how much time I have, but 2 minutes. I was asked, as I said, because I had this challenge and the passion to rectify this legislation, to remove the discrimination towards our women. Because as you know, and you've probably heard it, that within our tradition culture, we were not like one step behind, or we weren't sort of looked down upon. We had the same recognition. We had our roles. We had our rights. The women in our communities were very strong. And that was the balance to harmony. So when the Anishinaabe Nation asked me to be the Commissioner on Citizenship, I did community consultations within the 43 First Nations and drafted our own. What I heard from our people, many stories, heartbreaking, and we heard that, divisions, families torn apart. But I have a draft, and it's called the Edibendagzijik, Those Who Belong, the Anishinaabe Nation Citizenship Act. So it's here, and I've asked for copies. But I want to stress one thing, and this is what I will take my last minute to read to you. What we have decided, and this is from our people, is that we will recognize these following members to be members or citizens at the Bendagzijik within the Anishinaabe Nation. Number one, every citizen of an Anishinaabe First Nation is an Anishinaabe Nation citizen. A person is entitled to be an Anishinaabe Nation citizen provided that the person can trace their ancestry, their descendancy through at least one parent to the original people of the Anishinaabe First Nation, or, secondly, has at least one parent who is a member currently registered with the Anishinaabe First Nation, or the person can trace their descendancy through at least one parent to a status Indian who is registered or entitled to be registered with the Anishinaabe First Nation. And then there was a fourth one that was added more recently by a First Nation resolution. So these people will be members and recognized according to the to our Anishinaabe Citizenship Act. And one last thing. The Indian Act, as you know, wasn't decided by us, but there's another aspect, and I'm sure there'll be another court challenge, and it has to do with the treaty rights. Because as you know, treaty rights haven't been even looked at, but there is something coming up. And my mother, who had her treaty rights, when she married my dad, who was non-treaty, it was decided by someone somewhere that she also lost her treaty rights. So it's much like marriage, but someone decided somewhere. No one knows. I asked a lawyer in the Justice Department. He says, not written anywhere, arbitrarily decided. That'll be another aspect to be rectified. So, miigwech, thank you for listening.
Thank you very much to all of you for your testimony. We'll move now into questions. This is a round of 7-minute questions, and I'll use the yellow and red cards the same way I have. Yellow is 1 minute remaining, and red is let's finish up. And the first question is coming from Mike Bossio, please.
Thank you so much for being here, Jeanette. I don't know, I doubt you'll remember, but we actually met in 2014. You were at the Mohawks of the Bay of Quinte for the Restorative Justice for Native Women's Association symposium that I happened to be at, and I heard your full story. Your daughter was with you at the time, I believe. Actually, it's the book that I'm actually writing in right now that we received that day. Funny enough, and so yeah, your story was a beautifully told that day. It was touching, and it was my first real introduction to that history of Indigenous women and the injustice that occurred and is still occurring. This is such a complex issue, as has been raised by many different people, and I look at it, and I know some people are saying, we should go back to the courts and we should ask for an extension, and because we need more time to study this. And I don't think anybody disagrees that we need more time. We absolutely need more time. But right now we have an opportunity to add up to 35,000 people to that status. And in an extension for more time, I mean, we all recognize that the Indian Act is the fault. We're putting, as Chief Bellegarde said, we're putting a Band-Aid on a large cut, and I don't think anybody would deny that. But that has been and continues to be a generational evolutionary change. And I look and I say we have an opportunity to add 35,000, we can fix it and we can add hundreds of thousands, but how long is that going to take? Not even just getting it through the courts to get that recognized, or getting it through consent and negotiation and to get it recognized, but also even just to prepare for that outcome as well. Right now in my community, it takes 2 years for a Mohawk to get a status. How long is it going to take if today we add hundreds of thousands to that number, and let alone health, housing, land, as Chief Bellegarde pointed out. Land is a huge issue. I mean, I know in my community, once again, the Mohawks of Bay of Quinte are on you were there. It's a small piece of land. In order to add a lot more people to it. So I guess I would ask you for your opinion. Do we need to make this a multi-stage process so that yes, we can get it right, we can finally get it dealt with, hopefully finally deal with the Indian Act once and for all, but that is going to, in my view, take time, but I'd like to know your opinion. Both of you.
Well, just listening to the previous presenters, my own experience, and I'm just speaking, from what I think would be best for people, like within our communities, is that if we can make a change now, or February, and bring that recognition to those people, to me that is good. Because when in 1985, when we were reinstated, it was major. You just felt it in my children getting their status. It made a big difference. So it will have a tremendous impact on those, would you say, 35,000 members who may be affected as part of that. And it will boost them, their sense of identity, their recognition of their family, their history. All that is really important because we're striving for nationhood. And nationhood definitely has to have land, has to have people. And if we continue the way we are within the Indian Act, and that was pointed out, there's a reserve right now in Ontario, Skookal. I think 2013, they had their last status Indian. What's going to happen to that community? So changes do have to be made. And that's what we were talking about within our Anishinaabe Nation citizenship law, is that we want to recognize all those members who can trace their descendancy. And the Grand Chief and all the chiefs within our nation have agreed to it. It's the only way we can see that we can continue to be a strong nation, that we'll be able to go forward, that we can maintain our language, have our history, our spirituality. All that is key. And if we're going to be recognized as on a nation-to-nation basis to be dealing with the government, we have to have that strong basis, and that's what we're striving for. So I can see, like Grand Chief Pat, he said, recognizing your deadline is February. However, we will continue to work with the government because we've already started it. And we have that knowledge, the expertise. We can do that contact out to our communities, bring the elders in. They still have that history. And they'll be able to tell us, yes, this is what happened, in those times when those treaties that were signed. That's all really important. But I think, and I don't think I can say on behalf of our Grand Chief Pat Madabi, but I think that you should do it in February, and it will make a positive change.
Go ahead, Robert, if you'd like to add.
Yeah, I'm have the same thought as my friend here next to me. I think that we should go ahead. There will be people who fall through the cracks, but let's hope that in phase 2 that this will be looked at and remedied. I think that this has lasted so long. Let's get as many people on board as possible now, with corrections coming forward in after February 2017.
Okay, thanks. We're out of time on that one.
Oh, okay.
Yeah. Next question from Arnold Vierson, please.
Thank you, Mr. Chair. My question for Mrs. Levy. You said just a minute ago that you said that the Indian Act is our only protection. What did you mean by that?
Well, this is the only piece of legislation that has been determining who we are. For a while, we weren't persons, but I guess that particular section was changed. But it's the only protection that we have in terms of protecting our land, the little bit of land that we have left. And if we didn't have the Indian Act, if we go to some of those other proposals like fee simple, then even that may not be protecting our lands anymore, and we'll see our territories and our reserves diminish. But our people, the elders especially, they don't like what the Indian Act did to them, where they couldn't leave the reserve, they couldn't sell their produce. All those inequities were there. But we're looking forward to working together to make it better. And it won't be perfect, but little by little, we have, under Bill C-31, brought many more of our people back to our communities and feeling that sense of pride and identity. So the Indian Act, it probably will eventually have to be done away with. But when that time comes, hopefully we will have our own constitution, our own governance, and we'll be able to provide that kind of leadership to our people.
I see that here that you're the citizenship commissioner for the Anash. I always say it wrong. The nation. Anishinaabe Nation. I learned yesterday that there's Section 10 and Section 11 First Nations, depending on how you fall in. Which one is Anishinaabe Nation? Are you sure?
Don't think I understand what you're asking me.
So do you have a? It looks like you're building your code right now, right?
Yeah, we're working on it.
Okay. Now, do you have members that are part of your nation that are not status?
Yeah.
Yeah. So they're bona fide by your nation, but not by the Indian Act.
Yes.
Okay.
Exactly, and that's what I said. We recognize if you can trace your descendancy through one parent, could either be, on either side, then you are entitled to be registered as a member of the Anishinaabe Nation or Edwendauxet, those who belong.
Would you be appreciative if the members that your band recognizes as members of your band, that they would get status through that process as well? Is that something that you would be interested in? Is that something that you're working towards, I guess?
Exactly. That's what we're aspiring to, because right now we are losing so many more of our members under the current system. This is one way of ensuring that we don't lose any more of our people.
So
we cannot afford to lose any more of our members.
So you would be appreciative of the fact is that when you grant somebody membership to your band, the status would come automatically with that.
If that's what we are going to be working towards, it would have to be.
That's what you're working towards?
Because we will have our own registrar, we'll have our own body of governance and leadership to determine all that.
Okay.
And it's all been drafted already. Didn't have time to really get into it. But
you mentioned a band that has no more status members as of 2013.
That's under the current Indian Act.
Yeah. What do they have a banding council then?
Yes, they do.
They do?
But I believe what was happening is because so many of their people lost their Indian status over the years, and it's dwindled to the point where even with Bill C-31, it made a slight change, but we still have to continue to ensure that the grandchildren, maybe even the great-grandchildren of those original members are not lost. And I think those are what those other bills and Bill S-3 is going to do.
So there's still a reserve there, and there's still a banding council that's operating it?
Yes.
Okay. Has there been any interesting conundrums that have come out of that? Or has it continued to function fairly normally?
Well, it's still functioning right now because it's just happened. And but they did a study, and that was the outcome of the study. It said that with their current membership and the way things were going, they said, that's what's going to be the end of their members, who could be registered as status Indians. Okay. Unless changes were made. And this is why we came up with our Edwendauxet Citizenship Act. If they could trace, their descendancy, their ancestor, to one parent on either side, they would have been able to be recognized and be members of that community.
The worry is that you would have a reserve with no people tied to it.
That is the ultimate worry, and I believe there's several. On Manitoulin, there's a reserve. It's a small one. There's no members there, but it's still a reserve.
Okay, and there's no one lives on the reserve anymore?
No.
Okay, interesting. I'll cede my time, Chair.
Okay, thank you. The next question is Romeo Saganash, please.
Yeah, thank you, Mr. Chair, and I want to thank the panelists for their presentations. I find it kind of ironic. I would find it kind of ironic that we wouldn't be able to get an extension to look further into this issue. Government certainly has no problem right now not respecting the orders of the Canadian Human Rights Tribunal over First Nations children. This government has proposed a new relationship with Indigenous peoples based on the implementation of the UN Declaration on the Rights of Indigenous Peoples. I also heard the Prime Minister not too long ago, almost a year ago, in Gatineau, promising to, and this is his word, rescind any legislation unilaterally imposed on Indigenous peoples by previous governments. He did not say the previous government, he said previous governments. When I heard that last year, my first thought was about the Indian Act. Of course, I think naturally everybody thought about that. J'aimerais peut-être poser la question.
I think I'd like to ask this question to Mr. Bertrand and also to Mr. Cote, who is next to him. In the legislative proposal that came out of the ANC, do you see a compatibility with UNDRIP? You mentioned Article 33, for example, and also Article 9, which concern us. So do you see that is being compatible with the declaration and the legislative proposal that we're looking at, the bill from the Senate? Thank you for your question, Mr. Saganash. It's very important and very interesting. I think the sticking point here is this famous deadline of February 2017. The CAP would like to have more time, obviously. I think that's probably what everyone you've heard from this afternoon has said. They all want more time. But unfortunately, the Superior Court of Quebec imposed that deadline. We've spent a lot of time talking about it, and we arrived at the conclusion that it might be better to start with this first step and then to hope that in phase 2, the other issues will be settled. And I think there will be other issues that emerge that we will have to deal with in phase 2. So I'll give you a comparison. If you imagine someone who's very hungry, who's looking at an apple tree, and he sees 5 or 6 apples that are ready to be eaten, but the rest are not ripe. But the man is hungry. So is he going to wait for all of the apples to ripen before he eats them? Or will he only eat 5 or 6 apples? Well, I happen to believe that he should start by eating the low-hanging apples, and the other ones will ripen in time.
Yeah, I think, and talking to our Grand Chief, Pat Madabi, I asked him, and we had a workshop in September in Sudbury, and it was agreed that we have done quite a bit of work already within our own governance structure. We just need to get to the next phase, which would be the implementation. And this is where we would be looking at phase 2 to assist us to do the next phase of the implementation aspect of our Citizenship Act. So I think it's we need to start because it will help certain people, and Otherwise, who knows how long it's going to take? You know, it's.
But my question was specific. Are these proposed amendments to the Indian Act compatible or consistent with the UN Declaration on the Rights of Indigenous Peoples?
Well, you would have to tell me if they are.
Mr. Bertrand?
Mr. Saganash, I will let Mr. Cote answer that for me, if you will. He's a lawyer.
To answer your question, plain and simple, no. I mean, this is being imposed, as was previously stated by Robert and Jeanette, and also the previous witnesses that appeared before us, that there's a tight deadline. And this is being done because of that tight deadline. But I would only hope that, the government did commit to first enacting DRIP, but then also enacting it in a certain form that's consistent within Canadian law. So I'd hope that they would take, in this case, Article 33, and use that as a guide when they're moving on to stage 2 of this phase. Because, we should be able, Indigenous people should be able to determine their own citizenship. We're in this problem with the Indian Act because it's been unilaterally imposed from 1876.
I rest my case, Mr. Chair.
Thank you very much for the question and answer. The next question is from Don Rusnak, please.
Well, I expire in 2020. One of the questions I had, and I don't need this piece of plastic to tell me who I am. One of the questions I had was, who are these 35,000 people that are going to be able to get one of these? And what are the benefits to them? I'm one that looks at the long term and where we should be going as nations. One of the things we're doing as the Indigenous Caucus of the Liberal government is looking at nation to nation and what that looks like in the future. I was the executive director of Grand Council Treaty 3. It seems like forever ago, and we were developing our own laws. We have the natural resource law, citizenship law, and it wasn't some other government or some act that told us who we were. We decided as a people, as a group, based on our cultures and traditions. And in all honesty, I was learning because I grew up in the city of Thunder Bay. I grew up away from the culture and away from my people. The other thing that strikes me while we're sitting here talking about citizenship or status is how ridiculous this conversation is. That when I was just talking to my colleague, that imagine someone from Norway right now watching us talk about other Canadian citizens governed by an act and fighting to be part of that and not being your own people. So yeah, we have to move beyond the Indian Act, and I understand what you're saying. And Mr. Viersen had a question about why do we need those protections? Because there's a certain class of people, and unfortunately there is a class of people that live in a lot of my First Nation communities across my riding that would suffer if the Indian Act disappeared. And I don't think a lot of Canadians understand that. That the dependency is so deep. The Indian Act did its job. It destroyed our people. So I guess my first question is, who is the 35,000 people that would be helped by getting them under the Indian Act and getting them some of the benefits under the Indian Act? And can you answer that question, or should I be asking someone else that question?
Well, I don't feel comfortable in answering that question simply because it's a Quebec case and it's a First Nation in Quebec. And but if I look at the Indian Act and the implications for the non-recognition of certain members of their family, I can see the impact that it would have. And maybe they're going through the same process where their communities are dwindling and they're seeing the extinction of those communities. Maybe that's what they're concerned about, and this would be a way of alleviating that problem so that there will continue to be members within that Abenaki First Nation. And for whatever reason, they're not recognized right now. But Sharon MacIver did it for grandchildren, and then this is the next step. And I believe it would be like my son's grandchildren would be affected like that. We haven't reached that point yet, because we were just so happy just to go on the first level. But and I didn't realize, the implications. But I guess my opinion, if we cannot afford to lose any more of our people, and if we can assist and ensure that they have that right to be part of their community, to be strong within their ties to their people, then to me that's all we would need to know. And they can trace their ancestry to one parent. So that would fall within our Anishinaabe Nation Adventist Citizenship Act. So I can see that being applicable there. Maybe we should share it with them.
Well, I have a similar history. My mother regained her status, and again, I hate saying that means something, but it does in a weird way. It's horrible that it does, but it does because it reconnected the community where I come from a community that was flooded out, and a lot of people dispersed, but what kept the members together, and we, of course, had other First Nation communities around the area. The history was originally they got kicked out of Quetico Provincial Park, and they dispersed. But some kept ties, some didn't. Bringing that community back and getting a lot of the people together to have status under the Indian Act helped a little bit to get that community spirit going again. So I understand that part.
It's history too, and we have our own oral history, and that's part of that. That would just be verifying that too.
So, in making these amendments to a horrible piece of legislation, doing it, I understand the argument for putting it off to get it right. But is this something that perhaps we are going to let people slip through the cracks if we rush this through, but at least we're getting some people connected before in many or some communities' cases it may be too late, and the rest of it can come in a phase 2 as long as this government is committed to that phase 2, which I believe they are.
If you permit me, I'd just like to answer your first question.
Briefly, if you could, we're almost out of time.
Okay, I believe the 35,000, it was INAC that came up with that number. If they came up with that number, I am convinced that they have the necessary information to find out everyone that it applies to.
Okay.
Thank you.
Perhaps that's something that the clerks can ask the department.
You have the list.
Get the information.
Yeah, okay, good. We are going to our final question of the round, and it's a 5-minute question, and it goes to David Yertiga. We have the full 5 minutes.
Thank you, Chair, and I'd like to welcome you guys to our committee here. I think S3 is a good start, but I think it could have been much better if the consulting process was much longer. Obviously, we do feel for anybody that's going to be falling through the cracks. And earlier, we heard from National Chief Bellegarde regarding land adjustments. Do you agree that you cannot just give a person status without a land adjustment? So I guess anyone who wants to answer that, or...
Well, it's obvious. If you have more people, you will obviously have to expand. And some of our First Nations have been doing it. And they're making arrangements with municipalities that are surrounding their First Nations so that they would be acquired and be able to be used by that First Nation. Land is a key part of our teachings, our connection to the land, and also the waters that goes with the land. These are all key resources, and our people recognize the importance of it, so it would have to be part of that.
So
We would have to include that in the second phase of the consultations, I'm sure.
You know, we're just looking at S3 is going to definitely bring more people to reserves. Obviously, a lot of people want to be attached to the land and using the resources. So my biggest concern is if there's no money attached to this, it's going to put a strain on a lot of the budget that you guys, for the schooling, the school, can the schools accommodate it? There's also other programs that will be also put under pressure. So do you think that part of implementing S3, there should be money attached to it? And
In the best of worlds, obviously, it should be. It would have to be.
Go ahead.
Just coming back to the first part of your question, as you know, CAP represents off-reserve Aboriginals. But the question that you ask, I would ask Mr. Cote to answer it, please.
I just found it a little odd, and please don't take this as an insult or anything. I don't mean any disrespect, but coming from the Conservative side, considering that the Harper government appealed this decision from the onset, and the Liberal government is the one who withdrew the appeal. Now, with that being said, going to the second part of your sorry, let me finish the first part. Consultation, yes, guaranteed. There needs to be more consultation, but that's just general on all aspects. I mean, the courts have been clear in terms of consultation within the legislative body. I mean, in a legislative process through Mikisew. I mean, they went to court, they won, dealing with the omnibus bill and changes to SIA. Going to your second part of your question in terms of money, yeah, there needs to be more money injected with it. When Bill C-31 was enacted, there was some monies, but definitely not enough. I mean, there was some housing monies given, but definitely not enough to meet the demands that the communities face. And with C3, there was actually no monies injected when C3 came into effect. So when these people returned to the communities and asked for programs and services, it was a huge strain on communities. So definitely more money is always welcomed and needed.
Mr. Chair, I'd like to give my rest of my time to Kathy.
I do, just for the record, want to note that this decision came down during the election time, and Cabinet does not meet during that time, and caretaker provisions kick in terms of keeping options open for a future government. So I just thought that was an important piece for the record. This was during a writ period where there is caretaker only, where options remain open. Thank you.
We all done?
I had to get that on. I couldn't. I couldn't resist.
Okay, well, we are out of time on that question. Did you have a short?
Yes, Mr. Chair. I would just like to leave the committee with one small bit of information. And I mentioned it in my notes, but I want to make sure that everybody goes home with it, is that Bless you. Right now, there are 70% of Aboriginal peoples that live off reserve. And CAP is the one that is out there helping them. And I just wanted for you to take that back and whenever you write your report, to make sure that is included, because we find that sometimes we are set apart, and I think with all our constituency that we represent, we should take a more active role, Mr. Chair. That's all I had to say. And thank you so much. Thank you so much for having taken the time to listen to us.
Could I just make one comment about the off reserve? I totally agree. We should not be concerned about our reserves being flooded, by people returning, because of my 3 children, only one is living on the reserve. The other 2 are out, within the broader Canadian society. So there will be that give and take. So it's, I don't think it'll be that big a problem.
Thank you all for your testimony and your time today, moreover. Thank you. May I have a motion to adjourn, please? Don Rusnak. Thank you.